but I remember it's still morning. Everybody ready?
Yes, Your Honor.
Do I have a court reporter?
Yes, Judge, I'm here.
Oh, I see you. Good morning. The court calls for hearing cause number CR-2056-19-A, the state of Texas versus Ricardo Molina. And this is the final pretrial hearing.
Good morning, Your Honor. Michael Gassa.
I'm sorry, hold on. I was just gonna say, this is the schedule as of right now. Is next Wednesday is the impaneling of the jury. That's gonna be done by Judge Singletary. He has been gracious enough to substitute for me for the impaneling. And then Friday is the jury selection. And then the following Tuesday is the actual evidence portion of the trial. Now I will take announcements from the lawyers.
Good morning, Your Honor. Michael Gassa for the state of Texas.
All right.
Your Honor, good morning. Carlos Garcia, Jared Navajar, and Sergio Munoz Jr. on behalf of Ricardo Molina.
All right. Anybody else? Is that it? All right. Just this morning when I came in, I got a motion to quash prosecution for lack of constitutional authority that was filed by Mr. Navajar. I guess it was filed yesterday, but I just got it this morning. Is there anything else I need to take up at this pretrial hearing from the state?
Oh, from
Nothing from the state. We do have arguments there, and we do have one housekeeping matter with the impanelment, Your Honor.
All right. Mr. Garcia?
Your Honor, Mr. Garza was gracious enough to circulate a questionnaire. I had a couple of edits, and maybe we could just discuss that perhaps when the hearing is over, but I think that's the only thing that's left.
All right. On the motion to quash prosecution, is that going to be argued by Mr. Navajar?
Correct, Your Honor.
All right. Very good. Mr. Garza, you said something about the impanelment?
Yes, Your Honor. Because there is a motion to recuse, a recusal on file, and the administrative judge assigned a visiting judge to this case, we don't feel that Judge Singletary should be impaneling the jury or really touch, any part of this case. I know there's other judges here that would be happy to pinch hit for Your Honor in order to alleviate the travel. We just think that because the 92nd District Court did recuse itself, that them impaneling the jury may, prevent some type of, or the appearance of some kind of a conflict there.
All right. Mr. Garcia, what's your position on that?
I would agree with Mr. Garza's assessment, and perhaps we could find another court to do the impanelment.
I wouldn't mind that at all. Is what I'm trying to avoid is having to go down on one day, then coming back, and then going back down on another day, and then coming back, and then going back down on another day. If somebody can do the impaneling for me, it's fine. I heard somebody say something.
Yes, Judge Valdez, and I'm only here because they're using our courtroom. This is Judge Singletary. And yes, actually, Mr. Garza and Mr. Garcia, they're both correct. I had meant to tell you earlier what I spoke to Judge Gonzalez, who's our administrative judge here, Hidalgo County. I did recuse myself from this case, but we do have a district judge who is visiting next week in the auxiliary courts, and he is assigned, he will actually be doing the impanelment. I failed to mention that earlier, but for that very reason, because I did recuse myself from the case. I didn't want to have to do anything, but you're good. You're covered. We'll have somebody for the impanelment. I believe it's Judge Molina from Stark County, if I'm not mistaken.
I appreciate that, Judge Singletary. Thank you very much. And thank you for taking care of that for me. I appreciate it. Any other problem with that, Mr. Garcia?
No other problem, Judge.
All right. All right. Let's move on to the questionnaire. Is there any problem that needs to be addressed?
I don't think there's really a problem. There's just like a clarification. Mr. Garcia said that he wanted question number 24 taken out. but actually he highlighted question number 21. If it's number 21 that he wants taken out, then we can, take that out. The one he had highlighted, I don't have a problem doing that. And then I think he wanted a word change on one of the other questions, which we will gladly make that edit as well.
All right, let's clarify. Mr. Garcia, which question are you talking about? Are you muted?
Question 21, Your Honor, Mr. Garza is correct. In the email, I'd stated question 24, but I highlighted 21. 21 is the one that I believe is that I would urge be removed, and I think the state agrees. And just the wording on number 20. Hold on. The wording on number 23, and then we're good to go.
All right, Mr. Garza, do you agree with that?
Yeah, I mean, I am willing to withdraw, to eliminate number 21, not because I agree with counsel's position, but just in order to get the questionnaire.
Then I'm going to authorize the final draft, the final copy of the questionnaire to be passed out to the prospective jurors so that they can fill them out. And y'all will have access to those, both sides, so that you can be prepared for jury selection. All right.
Judge,
Who's
this is
talking?
Judith.
Oh, thank you.
Judge, we do have the jury department as well, Ms. Laura, where she's our district. Laura Hinojosa and Stephanie from the jury department. I know on the questionnaires, I had spoken to Stephanie and he said that she wanted to know when could they get the questionnaires. That way we can get them ready before the jurors get here on Wednesday, because they do put them on clipboards with the pen. So that way we can get, or they can get that going before we start. I don't know.
I'm sure you can get them this afternoon, right, Mr. Garza?
That is correct, Judge.
Right, Mr. Garcia?
Yes, Your Honor.
All right,
Okay.
this afternoon.
Also, she mentioned that if y'all can please include, I guess, some lines on the top where the jury can put their jury name, their juror number, and their cell phone. That way it can be easier, so we can put them, or they can put them in order, our jury team.
We will make that edit as well, Judge. I think it
All right.
has juror name and jury number. We'll add another line for cell phone, telephone number.
Very good. Are we ready
Okay.
on the motion? I'm sorry, Judith, is there something else?
It's okay, Judge. And also, if the parties can provide us with the USB, that way the jury division, once they finish with the questionnaires, they can put them on the USB and give it to all the parties. That way it'll be easier for everyone.
We'll give it to
Okay.
council, not the parties themselves, but to council.
Or, yes,
Mhm. Mhm.
okay.
All right. Anything else, Judith?
Your Honor, there's just one slight little issue, a little housekeeping issue with the juror list. It was odd because it's never done in these type of cases, but the jury pool list was given to the court over a month ago. I think it was an inadvertent that it was handed over to the court. I just want clarification that that list has not been disseminated to anybody outside of the court. And would ask the court to inquire as such.
And who
It
are
is
you
not
talking
that-
about when you say the court? Judith?
Yes,
Judith. And did you hear
right.
the-
No, Judge, I got the list and one list and that's it. I haven't.
You're
shared
holding
with
on to it.
Yes, Judge.
All right.
Very well, Judge. That's
Thank you.
satisfactory.
All right, on the motion to quash prosecution for lack of constitutional authority. Mr. Navar, good morning.
Morning, Your Honor. And it's my first appearance in the case, so I haven't appeared before you before. And I just want to make clear first off, Mr. Garcia gave me the benefit of a Spanish pronunciation. It's actually pronounced Navar.
Navar?
But you could assume otherwise just reading the name. Yes, Your Honor. So, and first, this motion was filed late last night. It was actually after midnight, so it's timestamped today. And I just want to say it's not my intention at all to ambush anybody with this. It's just, and I can get more into the circumstances of the timing of the filing, but it is a constitutional objection, Your Honor, that arises from the Stevens case that was issued by the Court of Criminal Appeals after the last, pretrial hearing on the motion to disqualify the district attorney's office. And I touch on it a little bit in the motion regarding timeliness that had some delays in getting the transcript. And again, I don't think, well, for one, I don't want to put those facts on the record that if it's not necessary, because it may involve the court reporter's causes for some of the delays that occurred, which may have been some of his medical issues. But I think it's ultimately irrelevant because it is a constitutional based objection. And the Court of Criminal Appeals has been clear that Article 2801, the 7-day deadline before the final pretrial hearing is not relevant when it's a constitutional objection. The court, should consider it, including to an evidentiary hearing if that's called for, which I believe it is called for, but I could get into that further. But I just wanted to say that first.
Let me ask you, just for clarification, your motion is entitled a motion to quash prosecution for lack of constitutional authority. What is it that you're asking? Is it a motion to quash the indictment or a motion to quash the prosecution? And when you say prosecution, what do you mean by prosecution? Because I've read your motion. I've read very carefully. It sounds like what you're trying to do is disqualify both the district attorney's office and the attorney general's office. That's what it sounds like. If that's not what you're trying to do, tell me exactly what it is that this motion is trying to do.
Well, I think that's accurate, Your Honor. That's what I'm seeking. And I guess to answer the question, the question seems to get at, is it a challenge to the indictment or is it a challenge to the prosecution as
That's my
such?
question. That's my
Right.
question.
And I think part of our problem for the defense is that we don't know all of the facts in terms of by whom and exactly how this prosecution was initiated. But what we know, and so to that extent, I can't say that it's a defect in the indictment itself. I think it's a defect in the way the prosecution has been conducted to begin with the indictment, but continuing through now. In other words, it's not something that they can rectify by redoing the indictment, at least not under the current structure with this team of prosecutors, the way that it's been represented to the court.
Tell me, just for clarification, what exactly do you want? What are you asking for? Are you asking me to quash the indictment? Or are you asking me to disqualify the DA's office and the attorney general's office? The disqualification of the district attorney's office has already been heard. We had a long hearing and I denied the motion. That's behind us. What is it that you're asking in this motion? The way I understand it, a criminal case is always brought by the state of Texas, not by the district attorney or the attorney general or anybody else. It's brought by the state of Texas. The only question is who represents the state of Texas in this case. That was made clear at the last hearing. I thought it was very clear because I tried my best to understand who is lead counsel in this case, who's representing the state. My understanding is Mr. Garza's lead counsel. There was a young assistant attorney general sitting with him, but I don't think he participated. He just said he was going to assist, but I don't think he's ever participated in any of the hearings. He's been there, present. White, that's his name, Mr. White. So what I'm trying to do is clarify what is it that this motion asked me to do.
Well, and you're right. And Assistant AG White is actually, he may look young. I've seen him a few times, but he's an experienced election fraud prosecutor. He's been with that office under the AG for as long as I've been involved in these kind of cases. Criminal is not my normal practice, Your Honor, but I do constitutional and election law litigation. And Mr. White has been in that office since since 2012 when I started this business. So
Mr. Navar, everybody looks young to me. That's why I said maybe I shouldn't, but everybody's young to me. So.
Well,
Go
okay.
ahead. I'm sorry.
Okay. So, and this, I mean, your questions are good questions. And frankly, they're getting at sort of the conundrum that we find ourselves in as the defense. Because if you look at, and this is what I described in my motion, I understand your perception as the court, looking at who's talking at these hearings, it's mostly Mr. Garza from the DA's office. But the way that Mr. Garza, representing the state of Texas at the November 2021 hearing on the disqualification motion, presented the issue was to argue from the opening to the closing and in between when he cross-examined Mr. Rodriguez, the district attorney. His argument, their position is that this prosecution was initiated by the AG's office. It was sent to him and he's answering the AG's request to assist in the prosecution. And that under Stevens, I mean, and I understand they made this argument before Stevens was released from the Court of Criminal Appeals. That came out a month later, and it presents a big problem for them because now they're on the record as taking that position, trying to get away from the disqualification of the district attorney. And Stevens says frontally that the attorney general cannot, participate at least not unilaterally in a criminal prosecution. I presume Mr. Garza is, wanting to argue that, this is distinguishable because it's not a unilateral prosecution by the AG like in Stevens, but I've addressed that in the motion. Of course, we're aware of that. Stevens still applies and requires this prosecution to be quashed because the only way that Mr. White can participate is under a deputization order where he's under the formal supervision of the DA. And that is not what the state has represented to the court. And so I think we have to get the state's response on record to this motion to figure out, what exact evidence, we may need to get in the record to have this motion considered. And really, like I said, we're in a conundrum, Your Honor, because the state can't have it both ways. But as it stands now, there is definitively no evidence in the record showing that Mr. White is legally participating under the deputization of the DA. They have, in fact, argued the exact opposite, that as if the Attorney General's office is leading this prosecution and initiated it, and Mr. Rodriguez is just serving at their assistance.
Mr. Garza, do you want to address, and I'm still a little confused, Mr. Navar, I'm still a little confused as to what remedy you're asking for, but I'll let Mr. Garza speak if he has something to say. And Mr. Garza, I note for the record, I don't see Mr. White anywhere. Is he not available today or what?
Yeah, he's not here, Judge, but I can address all those things. I think it's pretty clear just from the record and the filings in this case. One, I think you need to be completely aware of the holding in Stevens because I think there's been a little bit of intellectual dishonesty here.
I've read Stevens also.
Stevens says that the AG can participate in a prosecution. They just cannot unilaterally initiate it. So let's just go to 101 of basic law school. Let's go to Black Law's dictionary. What is a prosecution? You get the definition of prosecution. It says it's a criminal action, a proceeding instituted and carried on by the due course of law before a competent tribunal for the purposes of determining guilt or innocence of a person. The operative word in there is before a tribunal. So anything that happens prior to that is an investigation. The initial letter that was offered in the hearing to disqualify our office, that letter occurred a year, if not longer, before an indictment was ever issued. And if you look at that letter and you look at the language in that letter, it very clearly says he is requesting our assistance in the investigation and any resulting prosecution that may come. Not, in the prosecution, because we didn't know at that point whether there would be one. If you look at the record further and you look at the indictment that was filed, it was presented to the grand jury by the Hidalgo County District Attorney's Office, specifically by myself. The AG nor any of its lawyers were present in that hearing, and a proper and paneled grand jury made a decision to render a true bill in this case. And at that point, the prosecution starts. Shortly thereafter, and we're talking June 6th of 2019, shortly thereafter, Jonathan White from the AG's office files a motion, a notice of appearance of counsel. Now, it does not take a rocket science nor a lawyer or anybody else to figure this one out. If he is entering and appearing in a case, that means that case has already been established. That means that somebody else already brought it and he's giving notice to the tribunal he wants to join in. But he goes even further in that notice to the court. And that's what's before you and before the public. And that is that he says, I will assist lead prosecutor Assistant District Attorney Michael J. Garza in the prosecution of this, clearly identifying what his role and that he's coming in to assist. This is important because on its face, just with the filings, Judge, you don't need an evidentiary hearing. You can see that the case was not unilaterally instituted. It wasn't unilaterally initiated by the AG's office. Every bit of evidence that you have before you in any of these hearings or anything that was written actually says that it was two people doing this, two agencies. The truth of the matter is our agency ran with the initial prosecution. We got it indicted, got it before a court, dealt with getting in a visiting judge to handle it, and Jonathan White makes an appearance into the case. So fast forward all the way to November of 2021, we have the disqualification hearing. At that point, this law of Stevens wasn't even in effect. And even at that point, these same facts were presented to the court. And it was clear from the record who was lead counsel, who initiated the prosecution before a tribunal in this case. And that was the Hidalgo County District Attorney's Office. So if there's any changing and pivoting of positions, first it was our office should be disqualified. Now it's the AG's office. Now, I agree that even though it's in dicta in the Stevens opinion, I think Jonathan White, who has not really participated in the prosecution at all in this case, I've been the one that's made the arguments. I filed the pleadings. And if you look at the pleadings that have been filed, Judge, his signature block's not even on it. But he is, as the letters and the documents say, he is playing a role to assist. And I think as such, he has to be deputized, which we are planning to do when he came down for the hearing, so that that role could be fulfilled under the dicta in Stevens. I don't know what they're going at. I guess the defendant believes that nobody should prosecute him. But this case, this prosecution was initiated by the district unilaterally. Well, it was initiated by the district attorney's office here in Hidalgo County, and the AG filed his notice of appearance to assist lead counsel, and I think that's clear from the record.
All right, Mr. Navar.
Your Honor,
Go ahead.
Sure, thank you. Several points, but just as a broad theme, first of all, like I said, the state is now trying to have it, as I anticipated, both ways. They're speaking out of both sides of their mouth. When we've moved to disqualify the district attorney's office, they affirmatively minimize their role in this prosecution and investigation by reference, by adversion to the attorney general's authority. Now that now they're on record saying, oh, it's not us, Your Honor, it's the attorney general's office under this election code statute, their prosecutorial authority. They just asked us to assist. Now that we're questioning that under Stevens, now they want to pivot and make the opposite argument. And Mr. Garza just went a complete 180 degrees difference. This is a fundamental problem. We have to have, my client has to know who he's being prosecuted by in order to make the proper arguments. The identity of the lead prosecutor and the lines of authority and the documentation of that is absolutely critical to the constitutional authority for this prosecution, period. So they have to clarify this. They cannot proceed with these ambiguities and obfuscations. And if we just go back, the evidence from the November 2021 hearing is in the record, but I see, I was going to share my screen, but it says I can't do that, but it's part of my exhibits from the hearing are from Mr. Garza's cross-examination of the district attorney here in the November hearing. And he asked him about that letter and the notice of appearance. And Mr. Rodriguez's testimony was that he was asked to assist. And Mr. Garza asks him, I highlighted it. So he's referring to the Attorney General, asking you to assist in the prosecution of this case, correct? Answer, yes. Next question. So it wasn't a situation where you, Rodriguez, initiated the complaint and sent it to the AG's office. It was actually the AG's office that got the complaint and sent it to you. Answer, yes, sir. So, I mean, what Mr. Garza is sort of adverting to right now is the fact that there are facts that can be used to argue either way in the record that's on file before you right now. They've got to make their decision as to where the lines of authority come from and where they run. They can't have it both ways because, as I said, under Stevens and under other case law, the actual identity of the prosecutor, the lead prosecutor, and whether Mr. White has been properly deputized is critically important. It is a central substantive question before the court can ever get to trial. And my clients got the right to know that. So they frankly can't have it both ways. They need to make a decision. And I would also say it's too late for them to deputize Mr. White at this point and act like it corrects all of the the prosecution's actions that have happened to this point. My client's entitled to know who is making certain critical decisions up to this point, because if it was the AG's office and Mr. White, that was unconstitutional and that's tainted this entire prosecution. So that's the basis of the motion to quash.
Mr. Navar, I think it's been pretty clear from the very start that Mr. Garza has been the lead prosecutor. And let me ask you this question: if hypothetical, if the district attorney's office is prosecuting any case and says Joe Smith is the lead prosecutor, he's the prosecutor for our office, and then somebody else comes in and does the prosecution instead of Joe Smith, you're saying that the defendant has an absolute right to know who the attorney is representing the party, the other party. The other party in this case is the state of Texas. The prosecution is brought by the state, not by an individual or by an individual attorney. It's brought by the state. It sounds like you're bickering over who represents the state. And I think all that has already been resolved some time ago. The only question now is whether or not Mr. White is going to participate. I don't see him here. If he's going to participate, he has to be deputized by the district attorney's office as a special assistant district attorney. And you're saying now that it's too late for them to do that? And what is that based on? What is your authority for making that argument?
Well, because, Your Honor, first, I would say, I mean, yes, we are arguing about who is the lead prosecutor and what are the lines of authority, but that's because it's directly relevant under the Constitution and under Stevens. If this were an issue of, if the DA had recently hired another, attorney to work under the DA's office, that's not an assistant attorney general, then that presents no constitutional issue. The only question is raised because Mr. White is employed by the Attorney General and exercising authority. His notice of appearance cites the statute that Stevens has held unconstitutional. So, it's not an issue that's going to arise in every case. It's going to arise when the Attorney General's assistant is exercising authority that's been determined to be unconstitutional. And I agree with Your Honor. I think you're trying to get at a very difficult question that, frankly, there's no case law on. I think we're going to have to figure out what happens with, Mr. Garza is now trying to argue, well, we can rectify this going forward for trial purposes and deputize Mr. White appropriately. Well, maybe that's okay for going to trial. But my position is that there has already been a taint in the prosecution under Stevens, under the Constitution, and we're entitled to know what actions was the Attorney General's office making, doing? What was their actual role up to this point? Because Stevens dictates that if they're leading and if they're not working under the supervision of the DA under proper authority and deputization, then those actions have tainted the prosecution to this point, and it's a violation of the separation of powers. It's a very serious issue. It's not to say that this case can never get to trial, but I believe my client is entitled to know some of those facts, and we can't be ping pong back and forth every hearing with the district attorney's alternating arguments. We've got to know what the real facts are and what the state's position is, so that we can present our arguments. And I would also say, Your Honor said earlier that the motion to disqualify has been decided, and we recognize you've ruled on that. But we are, letting the court know also that we need to re-urge that motion. But re-urging it requires us to know what the state's answer is to this current motion. They're sort of connected. They're interrelated, because the DA's own arguments back in November reflect why that's the case. They tried to, sidestep, sort of minimize the any appearance of conflicts with the DA's relationships by pointing to the AG's authority and participation here. Well, if now they're subverting the AG, as they have to under the law, to the DA's authority, we get back to a place where that really affects the substance of the disqualification, and it ought to affect the court's consideration of that factor. It puts the DA back on top where he must be under the separation of powers, which means that his personal relationships cannot be avoided by reference to the AG's authority, because the AG is working under the government code. If they're going to try to deputize Mr. White, the AG has to be working under Rodriguez's supervision and not the other way around. So I want to put on the record that we do intend to re-urge those motions, the motion to disqualify, and I can file that whenever we need to. But I would suggest that now I have to know the state's position about where the lines of authority have run to this point, and going forward, so that we can make the proper arguments.
All right. Based on the argument of counsel, based on everything that's been presented, the motion to quash prosecution for lack of constitutional authority is denied. We're ready for trial. Is everybody ready?
State is ready, Your Honor.
Defense?
We're ready, Judge.
All right, we pick a jury next Friday. A week from Friday. A week from tomorrow. 9 o'clock in the morning.
Very well, Your Honor.
All right, everybody gonna be there and ready.
Yes, Your Honor.
And you will work out any problems that you have with the questionnaire and prepared for this afternoon to be passed out to the jury, so that you have an idea of who's gonna be called.
That will be done, Your Honor.
All right, anything else I need to take up?
I'm sorry. Go ahead.
Go ahead,
Typically,
Mr.
we file motion and limines and kind of hear them right before, if we can't work them out. I don't know if the defense plans to file one.
We can address those on the date of jury selection.
Perfect.
Mr. Navar?
And for my part, Your Honor, I just wanted to say, I think it's understood, Mr. Garcia's announcement of ready is with the caveat, as I explained previously, that we do believe that Molina is entitled to an evidentiary hearing on this motion to quash, and we are re-urging the motion to disqualify the DA and the motion to quash. And so, I anticipate that when trial starts, that we'll get some documents on file before the beginning of trial, and we'll re-urge this at that time. Obviously you can make the ruling that you believe is appropriate, but I just wanted to put that on the record for clarification.
I'll allow you to make a bill if necessary. I'll allow you to do that.
That's what he's trying to do, Judge, just trying to protect the record. I appreciate
Yeah.
it.
I'll allow that to happen. If you have documentary evidence that you want to have admitted in the form of a bill, I'll allow that. But this case is going forward.
Thank you, Judge.
All right. Thank you all very much.
Thank you, Judge. May we be excused?
Yes, everybody's excused. Thank you.
Thank you.
Thank you, Your Honor.